protection of the profession of lawyer. I'm Mark Stevens, I'm moderating and your chair, and I chair the International Bar Association Human Rights Institute. This event is being WebExed, and so it's hybrid. There are strictly no photos as usual. We have one official photographer, and the event is organised by the International Bar Association's Human Rights Institute, the Council of Europe, the Permanent Mission for Luxembourg, the Council of the Bars and Law Societies of Europe, the CCBE, and the event is co-sponsored by Andorra, Belgium, Chile, Costa Rica, Czech, Estonia, France, Greece, Ireland, Italy, Lithuania, Mexico, North Macedonia, Norway, Poland, Philippines, Republic of Moldova, the International Commission of Jurists, Lawyers for Lawyers, the Commonwealth Lawyers Association, the American Bar Association, the Inter-American Bar Association, the Pan-African Lawyers Union, and the Law Asia. I think I was selected to moderate this session because I had a hit taken out on me, an assassination for my work as a lawyer. So you might think, that the person who tried to assassinate me was less than successful. I've also given this topic quite a lot of thought as a consequence. We have pleased with a wonderful distinguished panel, which I'll introduce in due course. But first of all, could I introduce Ernstine Kornelis, the Deputy Permanent Representative of the Grand Duchy of Luxembourg to the UN office in Geneva, who'll give a short introduction to the significance of the convention. Ernstine.
Thank you very much, Excellencies, colleagues and distinguished guests. It's a true pleasure to open this important event on behalf of Luxembourg and all the organizers and co-sponsors, and of course on behalf of Ambassador Mark Bichler, who would have loved to be here today, but who couldn't make it. So from 2021 to 2024, Luxembourg had the honor of serving as a member on the Human Rights Council. During that time, we consistently underscored the vital role of legal professionals in upholding human rights and the rule of law. More recently, Luxembourg held the presidency of the Committee of Ministers of the Council of Europe. And during our term, we have been very actively and very much engaged to finalize the Convention on the Protection of the Profession of Lawyer, the Luxembourg Convention, earlier this year, and the end of our mandate coincided with this. So we are tremendously proud to have played our role at this key moment to strengthen international legal protections for those who defend the rights of others. Lawyers are essential to ensuring access to justice, yet across the world, they are increasingly targeted simply for doing their work. Harassed, threatened, detained, or worse. Let me be very clear, this cannot be accepted as the new normal. The Council of Europe Convention on the Protection of Lawyers sends a clear message. Protection of lawyers is not optional, it is a legal obligation grounded in the principles of independence, integrity, and justice. It establishes concrete safeguards to ensure lawyers can act freely and without fear. Luxembourg welcomes this groundbreaking instrument and urges all member states of the Council of Europe, and indeed all states, because it's open, to join and to implement it. Its importance extends far across our region. So we look forward to today's discussion on how we can collectively ensure that this convention translates into real and lasting protection for lawyers around the world. Thank you.
Thank you, Ernstine, and thank you, Luxembourg. Well, ladies and gentlemen, we have a positive cornucopia, well, that should be a further cornucopia of talent as conversants here today. We've got next to me Margaret Satterthwaite, the UN Special Rapporteur with the mandate for independence of judges and lawyers. On my left, Christoph Henrichs, the chair of the Council of Europe Committee of Experts on the Protection of Lawyers. Next to him, Roman Zavrsek, the first vice president of the Council of Bars and Law Societies for Europe, the CCBE. And at the end, Sophie de Graaf, the executive director of the NGO Lawyers for Lawyers. Margaret, can I turn to you first? Tell us a bit about how you think this convention is going to impact on your work and your mandate.
Thank you so much. And I'd really like to thank all of the sponsors. It was quite impressive hearing the list of sponsors, and I think it really underscores the importance of the convention and how much of a priority it should become for all of us. Excellencies, colleagues, ladies and gentlemen, let me start by extending my gratitude as well, of course, to Luxembourg for opening the event and for giving its name, in fact, to the convention. We meet to really celebrate the first international legally binding instrument to protect the legal profession. The Council of Europe Convention for the Protection of the Profession of Lawyer is a milestone in the ongoing effort to bolster the protection of a profession that is key to human rights and at the heart of the rule of law. I think we would all agree that the convention could not be more timely. This is because, unfortunately, lawyers today are the target of myriad interferences and, in fact, attacks in countries around the world. The convention provides a response to these increasing attacks by setting a regional standard for what the protection of lawyers entails. It allows us to measure progress in protection, as well as identifying failures to take needed action. The convention provides a benchmark for lawyers, bar associations, and states around the world to use in reforming laws and advancing regulations to ensure lawyers can play their essential role. For several years, the Committee of Experts on the Protection of Lawyers, under the responsibility and guidance of the CDCJ, worked collaboratively and with true intensity. I mean, it's incredible what they got done in such a short period of time with such high level technical work. Together with representatives of ministries of justice, the legal profession, international professional associations, and international organizations, seeking the best formulation for a convention that would ultimately be global in scope. The convention was adopted in March 2025 and opened for signature on 13 May. I commend the framers of the convention for determining that it would not only be open for signature and ratification by member states of the Council of Europe, but also by non-member states. And it now remains to us to really give it a global reach. But why is the legal profession important? I want to take a moment to salute the contribution of brave lawyers to strong democracies, to human rights protection, and to enjoyment of the rule of law, not only on the European continent, but around the world. Every day, I hear of brave women and men who stand up for their clients, whether well-regarded or unpopular, who provide advice to those making important decisions, whether concerning highly valued companies or crucial family matters. And I'm reminded that the free exercise of the legal profession in fully functioning justice systems constitutes an essential feature of any democracy. The free exercise of the legal profession contributes to the right to fair trial, to ensuring access to justice, and to the oversight of state power and protection of due process guarantees. Lawyers' role in protecting the guarantees of a fair trial are especially important to recall, since such rights can never be subject to measures that abolish or entail their partial repeal. Fair trial rights are essential to core non-derogable rights, such as the right to liberty, security of the person. The right to fair trial is a key element of the protection of human rights and serves as a procedural means to guarantee and safeguard the rule of law. International standards provide that lawyers shall not suffer or be threatened with prosecution or administrative, economic, or other sanctions for any action taken in accordance with recognized professional duties, standards, and ethics. In addition to guaranteeing access to counsel, international standards on the right to fair trial also provide that accused persons must have adequate time and facilities for the preparation of their defense and must be able to communicate with counsel of their choice. And yet lawyers around the world have faced attacks for defending dissenters, protecting elections, advancing the freedom of speech, and for defending the rule of law and an independent judiciary. On the other hand, protecting independent legal profession protects human rights more broadly. The undue interference and restrictions placed on the legal profession in any country may open the door to systematic violations of the right to a fair trial and to equality before the law. By restricting lawyers from fulfilling their legal duties to their clients, states create a chilling environment. This often impacts specific kinds of cases. For example, some clients, especially human rights defenders and opposition figures, may be entirely deprived of legal representation when lawyers face consequences for representing them. And this is where the Luxembourg Convention fills a void. States must guarantee that those who practice law can do so free from intimidation, obstacles, harassment, or interference. The new convention is an innovative instrument. It echoes requirements that already exist in soft law, but it makes them a binding commitment for states to both refrain from these acts and to ensure non-state actors do not engage in them either. The new convention is an innovative instrument that sets up a comprehensive and bold monitoring mechanism in the group of experts on the protection of the profession of lawyer, or GRAVO, composed of independent experts. GRAVO will periodically evaluate the implementation of the convention in each state party through targeted questionnaires, exchanges with relevant partners, and even with on-site visits. I very much look forward to working with GRAVO once it is constituted. I welcome the involvement of civil society, bar associations, and law societies, since without the protection offered by an independent bar, lawyers are extremely vulnerable to attacks and restrictions on their independence, particularly from state authorities. Finally, a few reflections on what we can do for lawyers. Lawyers are strengthened and protected by their interaction and engagement with their peers and counterparts. I know that some organizations provide support for lawyers at national level through advocacy letters and through bar associations, or directly to the authorities when lawyers are facing threats. As special rapporteur, I engage to support lawyers and have found that there are even associations that find creative ways to support lawyers that are forced into exile, either briefly or permanently, and in extreme situations, including by helping them become licensed or finding them employment in their place of exile. I'm encouraged by these efforts and call on all lawyers associations to continue to be active and creative in our methods for supporting the legal profession as a bulwark against human rights violations and authoritarianism. In closing, I call on states across the world to positively consider becoming a party to this convention. I will continue to advance this call through my mandate. Those who drafted the convention and the states that have signed it should work quickly to ratify. They have shown us the path forward. Now let us take the next steps together. Thank you.
Thank you very much, Margaret. Really helpful. I'd like to turn next to Roman Zavrsek. Roman, the CCBE pushed the Council of Europe and encouraged them towards this convention. What was it about this issue that you felt the CCBE should take a role in it?
Thank you very much. Thank you very much for the question. So it's, of course, CCBE, through its long existence, discovered that there are many threats to lawyers. The lawyers could not practice. The lawyers could not offer their services to the citizens. What was the most important thing for us, that the citizens could get access to the court. And if the lawyers are intimidated or scared, they could not offer this. Therefore, we decided to propose in 2016 to the Council of Europe to start with this or activities concerning the convention. So, and we were really very much active in the shaping the convention. So the very genesis of this convention lies within CCBE, if I may say so. So we formally proposed to the Council of Europe the creation of a binding legal instruments to protect the legal profession, recognizing that previous non-binding recommendations were insufficient to address escalating threats. This was not just a theoretical concern, it was a response to concrete, growing risk faced by lawyers in their associations, risks that imperil the rule of law and access to justice for all. So we were also very much active within the process of the preparing the convention. So we were a constant and active contributor to the group within the Council of Europe. We submitted formal proposals on definitions, scope, and the core principles of independence, confidentiality, and the autonomy of the bars and law society. However, we also established a dedicated working group bringing together expertise from across Europe to ensure that convention would be effective in the context of diverse legal systems. As an official observer in the Committee of Experts on the Protection of Lawyers, we represent the interests of the profession directly, both in formal session and through ongoing dialogue. So our advocacy is reflected in several fundamental elements of the convention. So namely, the definition of the lawyer and the focus on the regulated profession, ensuring applicability across various jurisdictions. The robust protection for lawyer-client confidentiality. The guarantees for the independence and autonomy of bars and law society, recognizing their essential role and upholding professional standards in defending the rights of both lawyers and clients. And also the creation of two-tier monitoring system, enabling both regular reviews and urgent actions in response to serious violation. However, also to the non-binding recommendation, and even more, we are very much aware that even those countries which would not sign or ratify the convention, which we very much wanted for all of them, they could still implement the provisions of the convention in their laws, bylaws, and they respect the same standards. So that's why we think the convention is very much important for everybody and could become a very broad standard in the legal profession, of course, broad standard within the, not just within the Council of Europe member state, but even broader. So a key challenge and achievement was to ensure that the convention would be relevant and effective across the wide variety of legal systems represented in Europe and beyond. The CCBE coordinated closely with the member bars and law society, driving on their practical experience to ensure that the convention protection would be meaningful, regardless of national legal tradition. This adaptability is what makes the convention not only a European instrument, but a model for the world. So we really plea for a swift signature and even more ratification within and beyond the Europe. The adoption of the Convention of Europe's Committee of Ministers in March 2025 and its opening for signature in Luxembourg in May 2025 were historic steps. 17 states have already signed, but our work is far from over. The CCBE is actively urging all Council of Europe member states, the European Union, and non-member states that participated in its drafting to sign and ratify the convention without delay. Once in force, all other non-member states will be able to join, making this a truly international treaty. We are promoting the convention through awareness campaign, publications, and events worldwide, including making it the central theme of the European Lawyers' Day in 2025. Our goal is clear: rapid and broad ratification so that its protection becomes a global standard for the legal profession. And why this convention is so important for lawyers, justice, and the rule of law, for the citizens even more. This convention is not just about protecting lawyers. It is about safeguarding the very foundation of the rule of law. When lawyers are free to perform their duties without fear or interference, they defend the rights of all individuals, uphold justice, and ensure access to the legal system for everyone. The Convention's binding standards and robust monitoring mechanism will help to ensure accountability, protect professional self-governance, and reinforce public trust in justice. Ultimately, the Convention is a testament to the collective commitment of the legal profession to democracy, human rights, and the rule of law. By working together across borders, across legal tradition, we can ensure that lawyers everywhere are free to defend rights, uphold justice, and serve the public without a fear. Thank you very much.
Thank you very much. We've heard from Roman and the CCBE about the advocacy part of this. I'd now like to turn and call on Christoph Henrichs, the chair of the Council of Europe Committee of Experts on the Protection of Lawyers, without whom you were integral, Christoph, to this convention. It wouldn't exist really without your negotiating process. Do you want to just tell us a bit about that and what your hopes and expectations are?
Thank you very much for your kind words. Yes, I'm very happy to do so. And if I can add, I think I'm the only representative from a government, from a state a government sitting here on this panel. So I bring in the perspective of the states that actually negotiated the convention. A lot has been said by both Margaret and Roman about the role of lawyers in the democratic society and for the rule of law, and why we need this convention. And I would like to go a little bit further into the negotiating process, how it was set up, and present some key elements of the convention to you. As has been said very kindly, I had the honor to be the chair of the committee of experts that drafted the convention over 3 years, and it was not an easy process, certainly. The committee was formed of 15 members designated by the member states of the Council of Europe. And in addition to these 15 state representatives, we had a large number of observers, representatives from lawyers' associations that are active in the field of international protection of lawyers. For example, the CCBE, who actually did play a very crucial role in the negotiating process, and I can certainly confirm that from my perspective as well. Lawyers for Lawyers as well, you had a very active role in our group, and many other organizations. The result in the group was a very unique and fruitful mixture of government representatives and practitioners, each of them bringing in their own individual expertise and perspectives into our work. That mixture ensured that the text that we now see strikes a good balance, that it is consistent with the applicable rules pertaining to the legal profession, and that it sets standards that are efficient and actually do work in practice for all the different legal systems under which lawyers and professional associations work. And I can tell you that this was not always an easy process, because the legal systems can differ quite a lot, even within the member states of the Council of Europe, and certainly beyond that. So we did have to find wording that accommodates all different systems. If I can just very quickly go through some key elements of the convention, some of which also have been mentioned before by my previous speakers. The protection that the convention provides is twofold. It protects both the individual lawyer and the professional associations. And if you start reading the convention from the beginning, the first substantive article you will find is on the protection of professional associations. And that is a very strong signal that the convention sends right at the beginning. Professional associations play a vital role for the protection of lawyers. And they do so in double function. They can speak and act on behalf of an individual lawyer that is being threatened or harassed, but they can also promote and represent the interest of lawyers collectively in the public and political debate. And to be able to do so, they need to be independent and self-governing bodies, immune to external influences and free to exercise their function. And this is exactly what the Convention guarantees in that article. Another key article of the Convention deals with the professional rights of the individual lawyer. That article lists a number of activities that lawyers typically exercise in the conduct of their profession, and it obliges state parties to ensure that they can do so freely. That includes the freedom to have access to their clients even when they are detained, to communicate with their clients confidentially, and the ability to participate in court proceedings on behalf of their clients. Most of these rights seem obvious, but they are certainly not everywhere and in all circumstances, and this is precisely why we need the protection provided by the Convention. Adding to these articles, the Convention provides for protective measures, active protective measures for both lawyers and professional associations. Lawyers must have access to a lawyer or a representative of their professional association when they are detained or when their premises are being searched or when material of theirs is being seized. There's also an obligation on state parties to refrain from physical attack, threat, harassment, or other hindrance against lawyers, and also an obligation to ensure on the state parties an obligation to ensure that lawyers do not become the target of such behavior from non-state actors. Similarly, state parties are obliged to refrain from adopting any measures that would undermine the independence and self-governing nature of professional associations. There are many more details that I can't go into right now due to the time constraints, but I hope you get the picture. The Convention guarantees freedom for both individual lawyers and professional associations to exercise their activities, and it establishes clear standards and safeguards to protect these freedoms and rights. Another important element that has been mentioned before already is the monitoring mechanism that we establish. I'm only touching on this very briefly now, and maybe we can elaborate a little bit more of that in the course of the discussion. It is a two-tier mechanism. There is a committee of independent experts that do not act as in a capacity of state representatives, but entirely independent. They do regular evaluation cycles in the states, and they can also be addressed in an ad hoc situation outside those regular cycles if there's a particular critical situation in a state party. And they produce their recommendations and their reports. States have the possibility to comment on them. I'm sorry. And once that report is finalized and published, this will be brought to political attention. And so this is the way this committee can exercise their power, so to speak. So that's my quick overview over the convention. About the perspective, we have heard already 17 countries signed the convention on its opening day at the ministerial meeting in Luxembourg on the 13th of May, which is a very impressive number for the first day. We're of course hoping that many other states will follow in the next few months and will also proceed to ratification very soon. And can I stress again what also has been mentioned before, it is an open convention. Once it is in force, it is open to non-member states of the Council of Europe. And this is the chance to set a real global standard, a benchmark for the global protection of the profession of lawyers. And in that way, the Council of Europe, I think, has managed to create a real landmark with a really worldwide impact. Thank you.
Thank you, Christoph. I think that's wonderful. And one of the things I wanted to do now is to go to Sophie de Graaf, the Executive Director of Lawyers for Lawyers. Sophie, the key issues in this is, you know, you've got a global mandate. How is this going to impact on your work, do you think, this convention?
Thank you. Let me begin with something a lawyer once told us during an international fact-finding mission into attacks on legal professionals. If they can kill lawyers, they can kill anyone. At the time, she was facing serious threats due to the cases she handled. She explained to us that, as a lawyer, I am a target because they want to stop us, they want to silence lawyers so that we no longer give a voice to the ordinary people whose rights are violated. And tragically, she was killed a year later. Her words and fate encapsulate why the protection of lawyers is so essential and why the protection must be effective in practice. Lawyers play a fundamental role in upholding the rule of law and safeguarding human rights. But lawyers can only fulfill this role if they are able to carry out their work safely, independently, and without undue interference. That is why my organization, Lawyers for Lawyers, was established nearly 4 decades ago. Our mission remains the same. To promote and protect the independence of the legal profession worldwide. And in that light, we actively contributed to the development of the European Convention for the Protection of the Profession of Lawyer. The Convention affirms principles that are indispensable for ensuring the legal profession can function freely and effectively. And I'll highlight 3 of its key elements. First, the Convention reaffirms the principle that lawyers must not be identified with their clients or their clients' causes, and it connects it with the obligation for states to ensure that lawyers can carry out their professional activities and exercise their professional rights safely and independently. And this is crucial, because in practice, lawyers are frequently the subject of threats, surveillance, legal harassment, or even violence, precisely because they are associated with the individuals or the causes they represent. This month, for example, on World Environment Day, Lawyers for Lawyers published a research report on the increasing threats of lawyers defending the rights of communities suffering environmental harm. The report shows that environmental lawyers face stigmatization and vilification, legal harassment and physical attacks because they are associated with their clients' interests. They also made serious hinder and interference by state bodies, such as restrictions on access to information, surveillance, and searches and seizures of their premises. And not only lawyers working on environmental justice face these difficulties. Similar patterns affect lawyers representing asylum seekers, human rights defenders, members of the queer community, journalists, and lawyers handling corruption, land reform, or terrorism-related cases. These actions do not only harm individual lawyers, they undermine the legal system as a whole. And it is imperative that states respond with effective investigations when such acts amount to criminal offenses. Failing to do so sends a dangerous message of impunity and has a chilling effect across the profession. Beyond reactive measures, government and bar associations must actively raise awareness among state officials, members of parliament, and the general public of the role that lawyers play in a democratic society and what their independence truly entails. Secondly, the Convention also recognizes that access to the legal profession and the use of disciplinary proceedings can be misused as tools of intimidation or exclusion. For many years, we have supported lawyers who were unjustly denied admission or disbarred groundlessly, simply for representing, for example, political opposition leaders or people participating in peaceful demonstrations against their governments. For this reason, the Convention provides protection not only for lawyers, but also for those denied admission, suspended or disbarred contrary to its standards. Independent regulation and fair disciplinary processes are essential to a functioning legal profession. And finally, the Convention emphasizes the importance of the freedom of expression of lawyers and their associations. This is not a privilege, but a professional necessity. Lawyers rely on the ability to speak freely, within and outside of the courtroom, about laws, justice, and the rule of law. Yet lawyers who speak out often become targets themselves. We have seen this repeatedly. Lawyers penalized for exposing mistreatment of detainees, for criticizing proposed legal reforms, or for denouncing structural injustices. And it is important that lawyers and bar associations, as experts, speak out on rule of law issues, especially in a time where the majority of countries are experiencing an erosion of the rule of law. In conclusion, the Convention sends a clear message. The independence of lawyers and their associations must be guaranteed, not only for their sake, but for the proper functioning of justice itself. We urge states and bar associations to use this Convention as a framework for action, both to uphold protections and to foster public understanding of the vital role of lawyers in society. The Convention also explicitly encourages international cooperation, and that is essential, because there is strength in solidarity. Lawyers across borders must support one another to create and maintain an enabling environment for the legal profession. Lawyers for Lawyers sincerely hopes that the Convention will enter into force soon, and we call on states to take the necessary steps to make that happen. Thank you.
Thank you very much, Sophie. I think there are two really important themes coming out of this. One is the binding nature of the Convention and the fact that it's open to everybody once it's coming into force. One of the things that I'm interested in is how that's going to impact on a global standard, and I hope we can address some of that in the questions. I'm conscious that we have a number of state parties who've indicated that they want to intervene. And so if I can start by giving the floor to the Netherlands, Ambassador Paul Becker.
Ambassador Becker unfortunately had to leave a little bit early as a member of the HRC. There's a meeting called for the voting members, but I'd be happy. My name is Thomas Valkenhagen on behalf of the Netherlands Mission to make a quick comment. First of all, thanking you for this wonderful event and also, of course, the very valuable contributions for this very important convention that has been signed on the 13th of May. Netherlands is a proud signatory of that convention and would really call upon all member states here present to consider doing the same. We think it's a landmark. It helps lawyers protection against threats, as your panel has rightfully mentioned, and also apart from that would help set equal standards and also help in situations where there's international cases and lawyers are across borders representing their clients. So that is a very core value for us as well on this convention. And our question to the panel would be, if there are states here in the room that consider their own frameworks already to be sufficient, what additional arguments and value do you see for them to also ratify this convention and join up? Thank you very much.
Thank you. I think that is a really important issue because I know that a number of members in the room are currently undertaking that gap assessment. Christoph, I wondered whether you had thoughts on that particular issue.
Okay, it's on. Wonderful. Thank you. Yes, thank you very much for your remarks and for your question. I think it is important that states come together to send a unified, collective, strong signal that they are protecting lawyers and that they're willing to do so. And if I understood your question correctly, it is certainly not sufficient for states to say, oh, we are already fulfilling the standards of the convention. We don't need to bother with the ratification because it's not adding anything to us. Well, two aspects to that. Number one, it may not be adding anything to their current standards, but I mean, nothing is for granted, even in states that feel they have a secure standard today. Who knows what their situation will be in 10 years' time? And in these fragile times, we've seen changes in the development in the standard of rule of law in countries that we probably 10 years ago never conceived to be likely. So I think even for states that fulfill all the standards already, it is important to give that a binding implication by ratifying the convention. And number two, every ratification adds to the unified collective signal. That's what I was trying to say at the beginning. And the more countries come together to ratify, the sooner the convention enters into force, and the sooner it will be open for non-member states of the Council of Europe to join as well, because that can only happen once the convention is in force. So to conclude, I think it is important, regardless of whether your national standards already fulfill the level of protection under the convention or not. It is important to do your homework as a state. I'm talking to my own state as well here, to get going and try to ratify the convention as soon as possible. Thank you.
Thank you, Christoph. And I think that possibility of promulgating standards internationally is obviously key to this and the binding nature. I give the floor to Norway, Ambassador Tomo Ernstine.
Thank you very much, and thank you for coming. I'm here in the corner, but I'm still with you, huh? No, thank you very much for convening us, and thank you to all the panelists for interesting interventions. I think we have to be mindful that the fine machine that we call rule of law consists of many parts and independent lawyers, and if I might add, the access to them for those in need is, of course, an indispensable part in that machine. So I see this convention as a very important step to counter a trend that we see emerging and that is very worrisome, namely the ambition of authoritarian regimes to change from within democracies by modifying core tenets of democracy typically, of course, to limit the independent judiciary, so as to arrive at a situation where you, in nominal terms, still have a democracy, you still have the institutions, but you have something that is hollowed out from within. That is something that we see in many countries. It's part of the playbook for a number of regimes, and I think therefore this convention is very, very important. So I thank the Council of Europe for concluding it. I thank the Council of Europe's people here in Geneva for bringing it to the global audience. I'm happy to say that my country already have signed, and that we support the ambition for this to be a global trend. Thank you very much.
Thank you very much for that and that exhortation. I give the floor to Andorra, Ambassador Costa Marismo.
It is a great honor for Andorra to take part in this important side event. Last May, Andorra proudly joined another 16 countries at the time in signing the Council of Europe Convention for the Protection of the Profession of Lawyer during the ministerial session in Luxembourg. This signature marks our clear commitment to protecting the legal profession, and we're already preparing for ratification with parliamentary procedures expected to begin this coming fall. Andorra's engagement dates back to the early stages of the convention's drafting. While no national experts were selected for the Committee of Experts of the Protection of Lawyers, we actively contributed through other channels. Notably, Ms. Alexandra Therese served on the Bureau of the European Committee of Legal Cooperation and was involved in reviewing the Convention's draft. We also wish to highlight the important role played by the Bar Association of Andorra, whose input and support helped guide our national position throughout the negotiations. This convention is historic. It protects lawyers against threats and interference and reinforces their essential role in ensuring access to justice and upholding the rule of law. Thank you very much.
Thank you very much for that and for, again, the endorsement. I give the floor to the IDLO. Mark, are you in the room? Yeah, thank you.
Thank you very much. Thanks to the organizers and also to the panelists for a really important conversation. I have to say, I grew up actually hearing jokes about lawyers. And yeah, everybody laughs, right? Except some of those jokes are really just built on mistrust and disdain for lawyers in the legal profession. And it's a real bad sign of how societies can actually treat those who we should be valuing and not scorning or fearing. And as an organization that's focused on using the rule of law for development purposes, IDLO was actually created to enhance the capacity of legal professionals in development, from developing countries. And why? The reason is because they really are pillars of development. So I'd like to just talk briefly about this value question. It's not uniquely a question of human rights. This is a question also about investment, business development, dispute resolution, trust in government. There are benefits for governments as well. And so, you know, lawyers, when they can work independently, openly, and without fear of reprisal, it means that people can invest, they can start a business, they can compete for contracts, they can resolve disputes. Government actually benefits because there are anti-corruption measures that can be better enforced, preventing illicit financial flows. I mean, the list is long. I could go on, but I just suffice to say that we really need to move beyond bad jokes and think about how lawyers really do add value to society. And I think from that perspective, I would just like maybe pitch a question to the panelists, is to think about not just this human rights standard and the obligations that are tied to this convention, but also if you could speak maybe about this value of defending lawyers, the trust that it creates, the benefits that states derive, so that I think we can generate that conversation, because I do think it is very important when we think about making this a concept that people will defend, not just through the Convention of Europe's treaty, but also beyond. Thank you.
Thank you very much, Mark. Did you want to respond to that, Margaret?
No, I was nodding my head.
So I saw you nodding in agreement. So I
don't want to take any time, but I will say that I do think that we often spend too much time on the defensive, but that's because we're on the defensive right now. And I think re-embracing the affirmative case that really does demonstrate that lawyers are protecting the rule of law in a way that allows for development, that allows for economic growth, and encourages also the resolution of conflict, et cetera. I think it's really important to keep that in mind. Thank you so much for doing that.
I mean, it puts me in mind of the research that was done by the World Bank and Oxford University on inflows from abroad in terms of investment, which tend to resolve around a free and independent legal system, encourages more because disputes will be honestly settled. So it was an interesting issue. Christoph, I wanted to talk a bit about it, and if anybody in the audience wants to intervene, please do catch my eye. But I wanted to come back to you, Christoph, on the emerging standards that we have here, the sort of binding standards we have. This is a document from the Council of Europe. So can we expect the European Court of Human Rights, for example, which is also Council of Europe, to cite to this in appropriate cases?
I think we definitely can, and that's a very important aspect of the impact that this convention has. And if you like, that's the sort of second level of impact. The first level is obviously for the states that ratify the convention. They make their commitments to the obligations that are expressed in the convention, and they oblige themselves to follow them. Good. But I think beyond those states that actually ratify the convention will have a strong influence precisely on the case law of the European Court of Human Rights. You very rightly said the European Court of Human Rights is a body that is also founded under the Council of Europe, and of course its prime task and responsibility is to interpret and implement the European Convention of Human Rights. But in doing so, it refers very frequently, and in fact increasingly so, to other standards that were created under the roof of the Council of Europe. And this is a binding convention. So I think the impact and the relevance that this legal act has for the European Court of Human Rights will go far beyond a recommendation which is not legally binding, just politically binding. Here we have a convention which was negotiated and unilaterally adopted among the member states of the Council of Europe. So regardless of the question whether individual states have ratified it or not, there's a declaration of agreement issued by the member states of the Council of Europe that this is a level for protection for lawyers that they consider appropriate and adequate and necessary. And I think I would not be surprised to see the European Court of Human Rights referring to that in its jurisprudence, in its case law, bringing this convention further than just the circle of the states that have ratified it.
Thanks.
And creating a proper benchmark there.
Yeah. Sophie, Roman, your view on that?
I think it's really interesting because we see a lot of cases about the infringement of the rights of lawyers at the European Court, but often from their individual rights, not necessarily connected to their rights they have as a lawyer to effectively exercise their professional activities. So I think it's really interesting if the European Court would actually reference the European Convention. And I think it's also very necessary to further develop the case law of the European Court, specifically on the rights and privileges that lawyers enjoy to effectively exercise their professional activities.
Yes, thank you. Yeah, it was an interesting discussion which I had with the two European Court for Human Rights judges. I would not quote the names, but they were relevant for the court. And they told me, look, nevertheless, the convention would not be signed by enough member states. Nevertheless, they will be ratified by enough member states. We will use the convention as our source when deciding about cases which are concerned by the convention. And this is the first tier, which is very much important. This is really something what we need to have in our minds. But the second tier is what we are also doing as a CCBE. We try to speak with the states which are perhaps non-member states of the Council of Europe or states which are still thinking about, and especially the Bar Association. When we spoke with them, so we said, look, there is a way which you could go. You could even implement the provisions of the convention with your bylaws, laws, try to, if this is the easier way, I mean, because we do understand sometimes that there might be some political discussion about the convention. If this is the way to go, and if this could be accessible for you, this is also the way how to put the convention in force, but from the inside out, which is also very much important. So we got also good reflections from Kuwait, Taiwan. So these are already the states which already approach us and ask how we could join, what we can do. We have some problems, we will need to wait, so could we start sooner? So, and this is very much important. So those binding provisions, even though they are not binding somewhere, they could become binding by implementing in the state and affecting on the outside level until they are binding for them as an international treaty.
I think that's really interesting, and how this is going to be a normative standard. Margaret, in your mandate, do you think you'll be referencing this convention as a sort of standard?
I think I will. Yes, I think it's, I mean, it really is, as we've already all said, a benchmark. And this is an area where there's a lot of soft laws. We know the general principles that exist. And there is a significant amount of work, of course, done by treaty bodies as well. But in the very specific provisions that are in this convention, it's really unparalleled. And so having a binding convention that sets out these norms will be a huge benefit and will allow me to really articulate those obligations more clearly.
I mean, it's one of the things that's always troubled me, that within the rule of law, the independence of judges and lawyers and the legal profession has never been elevated to a sort of standard in a constitution or a Bill of Rights. And I wonder whether this is a sort of proxy for that. And I really hope that we're going forward, because this is the first internationally legally binding convention aimed at protecting the profession of lawyers. And of course, as you say, lawyers are the key actors in the realization of human rights, and for this reason are exposed to systemic attacks, as many of us know. And according to this convention that you've put into place, and we hope will be operationalized, lawyers can carry out their duties without any form of physical attack, threat, harassment, intimidation, improper hindrance, which is so often the case that we see. So it provides also, I think, this unique ability for non-member states of the Council of Europe to become a party to the convention, and extending its reach, and also becoming this normative standard, first through the Council of Europe, then perhaps through the European Court, and adopted in the African and inter-American system. So I think this is a hugely positive way of reaching out, and will inspire many states around the world to access the convention. And I think it's already started with many states doing that gap analysis. And so I draw this meeting to a close with the exhortation that states adopt, you encourage states to adopt, and develop this as a normative standard against which to measure compliance the world over. I'd like you to thank the panel, to Luxembourg, and all of you for coming. Thank you very much.